Hi, friends. Welcome to Murder Mavens, a true crime podcast. And today is day 4 of the Karen Reed retrial. My name is Lynn, and I want to give you a quick recap and my overall thoughts on how today went, and as well, maybe how this entire first week has gone so far. So today started out with the viewing. So this was field trip day where the jury got transported to where John O'Keefe's body was found, which is the former home of Brian Albert. And in a pretrial motion, they did rule that Karen's SUV, her car, could be, towed there or whatever, driven there, and essentially, staged where it would have been that night. And so before they head out to do the viewing, the judge gave them some instructions in terms of what they are supposed to do and not do and the purpose of the viewing. So the purpose of the viewing was to give context to testimony that is to come, because they're going to be talking a lot about, the scene of where it all went down. And what they are not supposed to do is conduct their own investigation. They cannot come back independently to that same location at a later date on their own time, etc. So they're not supposed to come back there and continue to look at the scene. They're supposed to take in whatever they're going to take in, observe whatever they're supposed to observe, and remember that they are not allowed to take any notes. It's really weird because they are allowed to take notes during the trial generally, as they're hearing testimony, but they are not allowed to take notes while they're on this field trip. And each of the lawyers, or one, I should say, one from each side, the prosecution and the defense, were allowed to give some cursory instructions before they were to head out. And when they were there, this was not televised, so we don't know what exactly transpired while they were there. But the judge told them, the jury, that the lawyers would, on site, point things out to them, like, please note this place here, So the lawyers are just supposed to kind of direct their eyes, essentially. They're not supposed to point out specifics beyond that. And from each side, one lawyer was allowed to kind of give a little opening, I guess. And so on the prosecution side, Brennan wanted them to note the street, the front yard, where the car was. He wanted them to note the flagpole and fire hydrant, and that there was concrete by there, because I think they are alleging that when John was hit by the car, he fell and he hit his head, I think, on that concrete. And he wanted them to note that on the Lexus, the fact that the taillight, the entire casing of the taillight, as it is visible, when they get there, it's going to look different, because in the process of, I guess, examining the evidence, it had to be completely removed. He wanted them to take note of the height of the bumper, I guess, because maybe that's going to line up to some injuries on John later that he's going to show. And he wanted them to take note of the fact that, I guess the SUV has like a hatchback or whatever, and then there's a railing at the top. And again, presumably that is because later he might show evidence that that lines up with some injuries. I don't know. I'm only guessing. Then on the defense side, David Yannetti, he gave some opening words to before they went out on the preview, and I think his were more like, "You got this, jury. You're just, I trust you guys." He basically said that, but more specifically, I think he really is placing a high value on the jury really coming to their own determination. And I think one of the things he said was, just use your own eyes. And I think in part that lends itself to use your own common sense. You're allowed to use your own common sense, because a lot of the things that the prosecution is alleging arguably kind of defies common sense a little bit. I mean, it sort of stretches the imagination a little if you were to believe it in whole. And so I think, he's starting to kind of plant that seed of, you just trust your eyes, use your own judgment, especially since a lot of, especially what has been presented in the first case, with the whole mirroring, for example, of the Sally Port video footage, like a lot of, he's, I think, setting up some context of, you can't believe everything that is being presented to you by the prosecution. So here's your opportunity to use your own eyes and make the evaluation for yourself. But more specifically, he wanted them to look at the second floor window of the house, the fact that the house has 3 front doors, the driveway, and the distance. I think he's going to probably later allege that the photos really make, he kind of already said, photos don't really tell you how big or small a space is, how near or far a space is, because that's true. Different, depending on camera lenses that you use, something could look really far away, can be made to look really far away when it's not. And so he wanted them to note the distance between the second floor window of the house and the lawn, between the front door and the lawn, between the driveway and the lawn, because presumably multiple people testified to walking in and out by this place and not seeing a body. And if Karen Reed had hit him, but when she dropped him off at the beginning of like the early wee mornings of the 29th, there were people coming and going who had testified that they didn't see anything. And I think asking the jury to take note of the distance is going to kind of get to the point that, how could you walk right by this and not notice that there was a body on the lawn when this was before like the huge, snowstorm or whatever? So I think that is why it does feel like, okay, they're looking at it all now, so I guess you could say there's an argument of, well, at least they can see everything, and then when they're hearing the testimony, they can check if that jives with their memory of this visit. But we're pretty early in the trial. This is day 4. I think the first trial went for several weeks, and so then the question is, is it going to be all that fresh in their memories by the time, like, they don't know the context by which they're being asked to look at this scene, this, these observations that they're being asked to take note of. They have no context for what they're looking for, why they're looking at this place. Whereas if they had heard some testimony on both sides, presumably, for example, and if they had some questions as to the plausibility or implausibility of a certain thing, and then they go to the scene, they can kind of vet that for themselves, and kind of do a verification in their own minds of whether that makes sense to them. But here they're just visiting it out of context of anything. So I don't think the timing of this, I feel, doesn't really help. I'm not sure who it helps or who it doesn't help, but it just seems odd to be doing it so early. Then they did call some witnesses. The first witness was Dr. Gary Fowler. He's a physician pathologist, and he's the person who, I don't think he ran the blood alcohol test on Karen Reed that evening, but he testified to the protocol and procedures for testing. And there's some debate about what is, I guess, the way that you're supposed to conduct these tests as it pertains to like forensically for legal standing, versus how tests are conducted for medical treatment, medical assessment and treatment. So, for example, a person comes into a hospital that might be suspected of, let's say, like alcohol poisoning, and they want to run a series of tests to see how much alcohol might be in their body. As it turns out, that is a different type of testing than the type of test that would typically be run forensically in a legal setting, where those results are meant to be more, I guess, reliable in a certain way. And so that was the context of this particular witness. The direct examination was actually done by Adam Lawley, who's the prosecutor who tried the case more or less solo on the first time around. And he hasn't really said much. He hasn't done any talking for the pretrial motions. This is kind of the first time we've heard him speak in the whole process of the retrial. So it was a nice, tight, direct examination. Miss Little did the cross-examination, and she really underscored the differences between the fact that at that hospital where Karen Reed was taken when she was Section 12, and where the blood alcohol test was administered, that it is a clinical lab, meaning for like medical assessment and treatment, versus a forensic lab, meaning legal, whatever results need to kind of have some legal, standing, and it's the standard for a legal setting. And they talked about the differences of how the tests are conducted. And I think at the end of the day, there's to get into the specifics a little bit, when forensics testing is done, it's conducted on what's called whole blood. So that's like the blood as it, as you see it and know it when it comes out of your body. When Karen Reed's blood alcohol test was tested, it was tested using plasma or serum testing. And that's more when they draw your blood. You know how if you do like a blood draw, they draw it into those little tubes. Well, what happens after it's in those little tubes is it goes into like a machine, spins it around. It's a centrifuge. It spins it around and it separates the plasma of the blood from the other liquid of the blood. And then what gets tested is on the plasma. And so they're not using all of the blood. It's just two different standards, two different uses, and each of those methods has limitations and can be impacted by different things. And also, I think more importantly, I think this didn't come out, only parts of this came out specifically, but when they're doing the plasma testing, they're not actually directly measuring the amount or percentage of alcohol that is in the blood. What they are measuring is the rate of NADH production. NADH is a byproduct of alcohol. And so they're actually measuring, in a clinical sense, the byproduct of alcohol being in your system, because they're measuring, the rate of production of this other chemical that is not alcohol itself, but has a direct correlation and is proportional to the amount of alcohol that's in your blood. But then that's like a derivation, right? And so it seems like one step removed, whereas, and they did not actually underscore this, but presumably, I guess, because they set up the context that these two tests measure different things. But I believe if they didn't say it directly, I believe it was implied, but they might have said it directly. When forensically the blood alcohol level is tested on a sample, they're again using whole blood tests, and they're actually measuring ethanol, which is alcohol, the amount of ethanol in the blood. So it's a direct measure of alcohol. And so it's interesting. The doctor was very defensive about this is a very good way to test things. We get good results. We get reliable results. We've been certified, blah, blah, blah. But at the end of the day, one of the things that was brought up during Cross was that the serum testing that's done in the clinical sense, where they're measuring the rate of production of this NADH levels, it can actually be and NADH is a byproduct of other things too, which can lead to an elevated reading. And I don't necessarily want to say like a false positive, because blood alcohol level testing isn't like, a yes, no, is it there or not. It's the amount, it's the levels of alcohol that's in your blood. So if there are other things that can contribute to what this NADH, rate of production, number, that then they correlate back to an amount, a blood alcohol amount, then you could get some false readings. You can get some elevated levels because multiple things might be contributing to that. Whereas, like if you're just measuring the amount of alcohol, there are fewer things that could be contributing to, some false numbers there. So that kind of makes sense why forensically the test that's being run is actually held up like more used as a standard forensically, when in a legal setting, like pretty big, decisions are being made as a result of those tests. So I do feel like that was a big deal to me anyways. But I'm big into the science and the facts of things. Okay, so then the next witness was Jason Becker. He is an EMT paramedic and firefighter. He was the person who was partnered with Daniel Whitley, who testified earlier in the week. And the two of them were answering the Section 12 call on Karen Read. So he talked about her demeanor, her attitude, why he was there, because there was actually, so there was a call out to the fire station to respond to the discovery of John's body. And there's a second call in response to Section 12 of Karen Read. And so he and Daniel were responding to that second call. So they went out there explicitly with that objective in mind. It's not that they were already there, like, tending to John and the discovery of the body. And so he was the big thing that Brennan, I believe, I think his big goal in his examination of both Daniel Whitley and Jason Becker was that, at least my takeaway anyhow, is that they're there to save lives. Everybody knows, everybody thinks of firefighters as heroes. They're the ones who run into fire when everybody's running out of fire. And his big point that I believe he was trying to make, and whether he was trying to make it or the point that I took away from it, is that they're there to try to assess the situation and provide support, medical support or whatever, recovery, treatment, etc., to the people who they're responding to there. And their first priority is not to collect evidence, to investigate a crime or anything like that. And so I think this is to proactively counter any sort of argument the defense might make of, well, if she said that she hit him, if she said this or that, and that might implicate she was a part of a crime, for example, or had committed some injuries onto John, then why didn't you write that down? And so it's to sort of, I think, preemptively take care of those, combat those arguments, because that's not their job. Their job is to take care of the people that they're finding, and to save lives, and to treat the injuries and whatnot. And in the case of Karen Reed, to try to calm her down, to assess the situation, and I think, quite frankly, they're tasked with bringing her into the psychiatric hospital, whether or not she cooperates and consents. They have to do it either way. And I think a large part of probably their training and their job is to try to like de-escalate, and try to, if somebody is not calm, to try to calm them down so that they go willingly, as opposed to them having to force her. And she was very compliant, and she was very cooperative. The cross-examination was done by Jackson, and the direct, by the way, was done by Brennan. And it was more of the same, with trying to impeach this witness with their prior testimony in front of the grand jury. So I guess they're allowed to refer to the grand jury, but they're not allowed to make reference to the fact that this case has been tried once before. And so they can kind of like allude to that, like they can say a prior testimony or whatever, but they can't outright say, so now in the first trial you said this. But I guess they can explicitly talk about a grand jury, because usually I think the way it works is a grand jury will meet to just see if there's even like any sort of evidence enough so to move forward with further investigation, and granting further I guess like discovery and things like that. And so I think that's just normal course of any trial, whereas maybe not every trial, but it is part of the normal course of a trial. And whereas a retrial is not, doesn't often happen that cases get tried a second time. And so a lot of, I feel like his cross-examination was nitpicking on, and then it's kind of like what I said during my day one recap that I was hoping would not transpire, which is that it gets so nitpicky that there's like a back and forth on seemingly details that don't matter at all. And that it becomes kind of tedious by the end of it. And that's exactly what I feel happened this time, because they were nitpicking on Karen. Part of what prompted Karen being Section 12 was that she said something to the effect of, if he dies, I don't want to live anymore. Meaning, if John dies, I don't want to live anymore. And so there's suicidal ideation, and that prompted her father to be concerned and to ask that she be Section 12. And so in the course of, and this is all transpiring that morning, that after John's body was discovered, and it's at the scene of the discovery, in front of the Albert House and everything. And so she was I guess saying a lot of things according to all the witnesses who have testified so far, but among them was that she was saying that she was sad and upset that her last words to John were in in a fight, in an argument. And what the back and forth nitpicking was that, I guess the argument is what they were referring to were the text messages, which have already been read into court, so we know that that's in now. And also she had left, this has not come in yet, but I know it from the first trial, she had left a lot of angry voice messages and called him a lot of nasty things and made some really bad accusations of him. And those were her last words to him. And so that's what she was referring to, because he never picked up any of those calls. Like, it's going to come into evidence later that she called him like a bajillion times and he didn't answer any of them. And those were her last words, were angry words. And I think anybody grieving would probably feel that way. But the quibble is that the prosecution, I think, is going to allege or something that her angry words to him were maybe in person, that the argument was in person, and that's why she hit him with the car. Because they're saying that she did it intentionally, that, you know, they are charging her with second-degree murder, which is intentional. It might not have been premeditated, but that she did it with intention. And so I think they are alleging that she got into an argument with him, hit him with a car, and then drove off, is, I believe, you know, their story of things. And so what the defense is saying is, no, her last words to him were voice messages, not an in-person argument back and forth. And so it went back and forth. It traded back and forth multiple times, and so many objections and multiple sidebars with the lawyers approaching the bench and having a private conversation with the judge. Even the judge seemed exacerbated by this by the end of it. And so that's how things wrapped up. And then the judge gave her standard instructions, and when they come back on Monday is going to be a half day as well. So I think we had a couple of half days, but she kept stressing that, okay, we're still on track, don't worry, because I think Thursday was a half day, today was a half day, and then Monday is going to be a half day. Thursday being a half day was due to some sort of like misunderstanding or scheduling error on the prosecution side. They didn't have their witness, who I think was supposed to testify, there and available to testify. So my thoughts overall on today, and also on the week in general, is that I didn't want to say anything about Judge Cannoni at the start, because I just wanted to kind of see how she would rule and how she would present herself in front of the jury, because I've watched a lot of the pretrial motions, and how she is with the lawyers outside the presence of the jury is one thing, but in front of the jury, she's supposed to present herself as being neutral, just, you know, an arbiter of the courtroom process and the law and the rules of evidence and all of that stuff. She's just supposed to be like making sure that everybody's playing by the same rules, and, you know, calling balls and strikes. You know, she's the ref, and she's just supposed to call balls and strikes. She's not supposed to be putting her thumb on the scales of justice at all. And I think for the first few days, she seemed rather measured and kind of treating both sides more or less equally. Kind of felt like, in terms of the objections being raised, it didn't seem like she was favoring one side or another. And in this courtroom, not that I'm a lawyer and could understand all of the legalities anyways, but in her courtroom, the lawyers, when they object, all they're allowed to say is objection. They're not allowed to say the legal grounds for their objection. And it's for her to decide if anything is objectionable, I guess, at all. Which is kind of weird, because I think sometimes it can be good, it can be bad, I guess, because if you're not a great lawyer and you don't know the grounds that you should object with, you could just say objection, and if the judge feels like there are grounds for objection, then you would win. But I know that sometimes I've watched other trials where a lawyer will say objection leading, and that'll be overruled. And then they say objection something else, and then that will be sustained. Or the judge might give them a clue. Like they might say objection leading, and the judge might say overruled with regards to leading. And so then that would give you a hint that, okay, there is an objection here. Let me try again and find something else objectionable. And then they would have to land on the correct objection for it to be sustained. And so, there's that. Like, it doesn't rely, I guess, so much on the lawyer being precise about what they find objectionable and being correct about what they find objectionable. But then it just seems it could seem very arbitrary too, because what if the lawyer sees something objectionable that the judge doesn't necessarily see herself? But if they were to voice it and she takes a moment to consider it, she would agree. So I can see arguments from both sides, but I feel like it's more fair almost to be, and both sides I think wanted to be able to say at least the grounds for the objection. I don't think that was anything any of the lawyers were fighting, but the judge doesn't want it done that way. And so I'm finding the first few days she seemed to be, sustaining and overruling objections. I didn't count, but it didn't seem like it was overly prejudicial one side or the other. However, I'm finding as the days go on and we're still early in this trial, I feel like when the defense is cross-examining a witness, she is directing the boundaries of how they are allowed to conduct that cross-examination much more than she is directing the prosecution. So, for example, the prosecution gets up and has their line of questioning, and unless and until the defense raises an objection, she really doesn't say anything. She really doesn't tell them to move on. She really doesn't tell them to stop interrupting. She doesn't tell them to do anything. She just lets them go on. And the conduct is not 100% the same, but there's similar conduct that the prosecution's getting away with. And I feel like the defense team is not given that same wiggle room or that same allowance to conduct their examination the way that they want, but that is also very much in line with how the prosecution is conducting their examination. So, for example, the judge will, and I think she's done this with just about every defense attorney, even Miss Little, who I think she kind of tends to like more than the other folks on the defense team. Even her today, the judge was like, let the witness answer, move on to your next question. And technically, when you're doing a cross-examination, you're allowed to lead the witness for one, so you can ask leading questions, and you can cut a witness off if they are about to just launch into exposition and exceed the bounds of the question that you asked. So if you asked a yes or no question and then they start going into storytelling mode, you're allowed to cut them off and say, please just answer my question. The question I asked was a yes or no question. Please just answer that in yes or no. And so I feel like that's all the attorney Little was doing, was just cutting him off because he was about to launch into exposition that, if allowed to, then opens the door to more testimony and redirect. And so I kind of feel like, I don't know, it just feels like Judge Cannoni is kind of in small subtle ways, starting to put her thumb on the scales a little bit. And so there's that I've noticed. The other thing that I've noticed, and this is more like a body language perception thing, so she may not even be aware that she's doing it, and that is that she often, and it can be as much, me perceiving this and her not really trying to put out that energy, but or feeling that way, and I just, am reading it that way. But I kind of feel like, when she talks to the defense attorneys, she's like a little bit tired of them. Like she's tired of hearing from them, and she just always seems exacerbated and like, oh, I'm so over it. If you must, like, what do you want to say? And when the prosecution speaks, she's like, oh, please do this. Yes, please. And and she's very neutral. I won't even go so far as to say that she's like, adoring or anything to the prosecution, but she's as she should be. She's neutral, maybe friendly, but she's more or less neutral, right? She's very friendly to the witnesses whenever it's, please take the stand. And then when you can hear the pitch of her voice change when she dismisses a witness, she's like, okay, you're all done for the day. And it's a very different tone and tenor. So yes, she's very nice to the witnesses. That's very clear. Nothing wrong with that. But when she's talking to the lawyers, what I would expect is just even professionalism, and the prosecution gets that. She just is like very matter of fact, a little bit on the more friendly tone, nothing wrong with that. When she's talking to the defense attorneys, she's got a little bit of something where in her voice, it feels to me, and in her body language and her face and everything, she just seems to be tighter, and she just seems to be like a little bit more curt, a little bit more annoyed by by them. And so if anyone on the jury is being affected by that, meaning if they are picking up on that, then those are some biases, whether she's aware she's imparting them or not, or whether she feels them or not. If jurors are perceiving that bias from her, then they're gonna then possibly and subconsciously take on those same biases, and they're gonna feel equally annoyed by the defense, because she'll often tell them, okay, move on, as if like, okay, this is getting tedious, let's move on, please. Whereas with say direct example is Brennan was trying to move into evidence yesterday, like a bunch of phone logs and stuff, and he had to kind of do this repetitive rigmarole of questions, series of questions, to move like 10 plus documents or something into evidence. And Judge Canoni is like, jury, this is just how we have to do things. This is how we have to move things into evidence. Kind of giving an excuse to the jury to be like, don't hate this guy. He's doing his job. I know this is tedious and it's boring, but we have to do this. He's just doing his job. Don't take it out on him that you're bored. and then it also breaks things up so that like they also maybe pay attention a little too, because he's just like one after another doing the same thing over and over again, and so when you tend to kind of maybe zone out a little bit, and so she breaks up that monotony a little bit, and then she makes excuses for him and in case the jury needs to understand why it has to be done. So I don't know. I feel like she's starting to show her bias, and we've talked in Killer Cards episode 3 about her relationship to some of the people who are kind of involved in this whole story, and that she might not be the most unbiased judge to be hearing this case, but here we are. So those are my impressions overall, and I kind of feel like today more than any day, Judge Canoni is kind of the defense's biggest hurdle. to be honest, because she's giving like an overall how she's conducting this and how she's calling, balls and strikes and stuff. It has a big impact on the defense, their ability to put on the case that they want the way that they want. I haven't talked about the pretrial motions and the things that have come up during the week, and so I'll touch on a little bit of that now, because the big thing, and it hasn't come to any resolution yet, and so that's why I haven't really mentioned it, but there's a lot of back and forth battle on late discovery and whether there's deadlines for when both sides have to essentially hand over to the other side whatever evidence and witnesses they plan to put in their case in chief. And one of the hot topics is the ARCA evidence from the folks who were originally hired by the FBI to conduct an inquiry on Michael Proctor, and this, as it pertained to this case, they were asked to do like an accident reconstruction, and they are super qualified to do this, like beyond qualified to do this. Some of the things that are credited to their firm's work is like pretty amazing and top level stuff. So they do very important work. They're very good at it, and they're more than qualified to speak on this topic. And yet, Prosecutor Brennan is fighting tooth and nail to exclude them, or at least parts of their testimony. And in spite of the fact that he keeps saying that he has no problem with them testifying. But he's fighting tooth and nail to allow in parts of their testimony. And now that federal investigation has concluded, and now, because while that was going on, the defense and the prosecution neither were allowed to employ or ask the ARCA team to do any additional testing, reporting, or anything. Whatever was generated for that federal investigation, it was handed over to both sides, the prosecution and the defense, and they could take it and use it, but they could not elicit any additional, facts or tests or anything from that company. But now that federal investigation has concluded, they were given the clearance by the FBI that, yeah, you can hire these guys if you want, have at it. We're done with them. They're allowed to do whatever they need to do with you now. And so that only happened, I think, as late as like February, this February, and they were doing pretrial motions about this in March, and here we are now in April, and the trial is underway. So it hasn't been that long a time that the defense has been allowed to actually talk to the ARCA guys with the specifics of this case, let alone ask them to conduct any sort of additional testing or reports for them specifically, and the things that they want to underscore, or for the case in chief that they want to present. And so the prosecution's super worried about what these guys have to say, and they're trying to exclude any further additional testing and any additional reports that were not already turned over in discovery. And so the judge is trying to at least show that she's being fair. And she said earlier that, look, these guys qualify as experts. They're going to be allowed to testify. And if a voir dire needs to happen, then it just needs to happen before they testify. That was her earlier finding or determination. But now all of a sudden, another scuffle, another, objection is raised by the prosecution, and she's all of a sudden saying, okay, well, because the defense, violated discovery, and as a remedy to that violation, then ARCA needs to have concluded whatever this additional testing is that they are supposedly doing, and they need to come in for a voir dire on Monday, meaning that they need to they're not from the state. I think they're from Pennsylvania or something, and this is all happening in Massachusetts. And so they need to like drive or fly into Massachusetts, take the stand, and be subject to questioning by both prosecution and defense, but really because the prosecution wants to hear what's going on, most of it's going to be from the prosecution. And they need to and outside the presence of the jury. This is so that the prosecution has fair notice, supposedly, of what they're going to say. And the thing with this is that what strikes me as kind of unusual is that the prosecution is supposed to basically just try to get justice and try to make sure that the laws of the land are being followed, and when they're not followed, that the correct, remedy is applied. And they're meant to be truth seekers in an investigation. They're meant to make sure that the truth comes to light and that justice is served. They aren't supposed to play for the win, irregardless of all other facts. And if there are facts that are exculpatory, meaning that they would tend to actually show innocence of the accused, they're supposed to, give weight, appropriate weight to those facts. They're not supposed to have come to a conclusion and by all means, and even if it's contrary to evidence being presented, credible evidence that's being presented, just follow like this path, this diehard path to, a conviction, in light of the fact that there's credible evidence contrary. And so what strikes me as odd is that the way that they should be putting on their case is to prove that the things they are alleging happened. And if they can't prove that, then that's what their focus should be on. Whereas it feels like the prosecution in this case with ARCA, they're just worried about what ARCA has to say. So they want to know what ARCA has to say so that they can prepare their story to be a countermeasure to that. But you're not supposed to adopt your story to counter the facts that are contradicting your story. If your story should be the truth. It shouldn't be a story that is like adapted to facts of the case that you don't like. So it just seems odd, because normally I think usually it's the defense who wants to know what facts the prosecution is bringing to bear so that they can properly defend against those facts with, whatever evidence they feel contradicts or, and it just seems really odd to me, this whole process. And I feel that Judge Canoni is behind the scenes, because all of this is happening outside the presence of the jury. This is where she is, I feel anyways, very biased or just has a very strange way of seeing things. And that has resulted in a lot of unfairness to the defense, and that a lot of why she's imposing this is because of late evidence being turned over, when the prosecution has done that time and time again. Late evidence trickling in all the time. And they get zero reprimand, they get zero, and they're even like applauded for such and such. It's just really ridiculous. And I didn't want to say anything about it because all of that's outside the presence of the jury. And while it has a very material impact on the trial, I felt, well, let me just watch her and see how she conducts herself in front of the jury. Because if she can be impartial or at least seemingly unbiased in front of the jury, then at least that's redeeming. um Even though she might be like putting her thumb on the scales of justice behind the scenes, at least in front of the jury she's not giving that impression. But now I kind of feel like she's doing it. That's just, she's doing it whether the jury's watching or not, and certainly we're watching, so we can see it all. So that's my thought on the judge, and how she's kind of conducted herself, and now she's kind of, I feel, made herself a player in this whole situation where she should really just be impartial to it all. The other thing that I'll say though is that she was like this the first time around too, and the verdict on that first trial, it was appealed, and the it stood. So the appeal, kind of overruled it and was like, no, we're going to stand by that. There was nothing, nothing to see, nothing to move on, keep going. And that's why this is under appeal with that first trial. Some of the results were under appeal, and have been escalated to the Supreme Court, and it's still being held. I don't think they've heard the case yet at the Supreme Court level. It's going to be really interesting to see if the Supreme Court takes this up or not. They might not even take it up for consideration, and that's probably the most likely thing that will happen. But we'll see, I guess, because that still hasn't really resolved. All right, so that is my day 4 recap, my week 1 recap, and so we'll continue with the recaps on Monday, which is also Killer Cards episode 4. We're going to be talking about the Alex Murdaugh case in a live stream. So I hope you'll join Wendy and I live, and we're going to be chatting about Alex Murdaugh. Thanks, everybody. Have a great weekend, and I hope to see you on Monday. Bye.